May it please your lordship. Lordship, in item 34, we filed the affidavit yesterday.
Item number
34, lordship.
34.
I would like to call it to the records, lordship.
Validity of what you have challenged the validity of?
I'm for the respondent, lordship. The
You're for the
service rules
respondent.
have
Sir,
been
this is a
challenged.
cat against the cat judgment or what?
Sorry, lordship.
This writ petition is a
No.
Four.
you're asking for four.
34.
34.
Item 34, lordship.
34.
What is under challenge in this petition?
The rules are under challenge and I appear for the respondents. Lordship had on the last date asked us to file an affidavit bringing into record the amendment which we had done in the rules.
That 30%.
Yes, lordship.
Yes. Numaligarh refinery.
Numaligarh, lordship.
Okay. And counsel appearing for the respondent. So please some time to.
No, lordship, I'm not praying for time. I want to bring the affidavit on record.
Already filed.
We filed it yesterday.
Yesterday, okay. Bring it on record. That.
Much
yes.
obliged, lordship.
May please your lordship. Lordship, I'm praying for listing of a matter, your lordship. Listing of a matter, your lordship. Actually, the matter has not been listed for a long time, your lordship, and the Assam Mala projects are about to be started in those districts. So, means like my anxiety is that, lordship, if the Assam Mala projects are started, lordship, my case might get in purchase, lordship. That's why I'm praying for a date on maybe on 17th of May, your lordship. It is not inconvenient.
17th May.
Much obliged, lordship.
May this lordship, I beg to mention item 14 with due consent from the other side, taking for adjournment for a day.
1-4.
Yes, my lord. In
The
case,
condemnation.
my lord.
The condemnation application you are for?
I am for the respondent, my lord. Petitioner. Respondent.
You already filed.
Objection, my lord. Senior counsel out of station kindly adjourn for the day.
One week.
Objection.
May I please, your lordship? My lord, with due consent from opposite party, my lord, I beg to mention item number 8, my lord. My lord, this matter may be adjourned for the day. Some instruction is coming, my lord. Only for the day.
Last time also we have granted, let the number come.
Yes.
May I
Yes.
please, lordship? May I please, lordship? Lordship, I beg to mention item number 6, lordship.
6, yes.
Yes, lordship. Lordship, the counsel for the petitioner is not able to do the matter today due to his personal difficulty, lordship. Lordship may kindly adjourn the matter for today.
You find the rejoinder,
Yes, lordship.
2 weeks.
Obliged.
Lordship's permission, may I mention item 38, Your Lordship?
Yeah.
I wish to file a rejoinder to the reply of the respondent number 3.
Yeah.
About a week's time would be needed.
That is elephant.
Yes. A challenge to a particular proviso in the Wildlife Protection Act.
2 weeks.
May I request for a specific date, Your Lordship, if convenient? Could it be 12th?
You ask the court master, he will give it.
Obliged.
May I please, your lordship? With due consent of the other side, I would beg to mention item number 30.
Yeah.
For adjournment, your lordship.
Adjourn.
3 weeks' time, your lordship may be granted, considering.
Adjourn. How much time do you
Obliged,
ask the
lordship.
court master?
May I please, lordship? Lordship, I beg to mention item number 25 for
Yeah.
adjournment, lordship. Lordship, the conducting counsel has suddenly felt not feeling well, lordship. Item 25.
Adjourn.
Obliged.
Yes.
May it be your lordship, with the consent of the other side, I beg to mention item 32, lordship.
3-2.
33, lordship, 32.
Yeah.
Lordship will file a affidavit within a day, lordship.
Adjourn.
Deeply applied, lordship.
May I please, your lordship, in item number 31, we had filed affidavit day before yesterday. May it be called for record. Much obliged.
Daily list for orders, item 1 to 3.
Yes.
Look, this is with regard to, my lord, construction of solid waste management plan in Nagaon, in my case, my lord, item 3.
Yeah.
On the last occasion, your lordship, pleased to, in item 1 and 2, your lordship was pleased to ask Mr. Das to appear as an amicus.
Yes, yes, yes. Mr. Das, you have to file some objections. We have granted you time on the last occasion. The paper which has already been supplied to you.
Yes. Well, look, I had gone through the entire three PLs. So I like to flag certain issues. Well, look, in these three PL, three very important parties has not been made party respondents, without which the entire issue, because your lordship has rightly taken up this issue as a pan-Assam issue, because a brief history, I'll just go to the background, brief, lordship. Well, since 1996, Almitra Patel, she was a pioneer of solid waste management. She's a social activist. She brought up the case of garbage
Collection.
yes, in the country. And this matter went up in the Supreme Court. And in 2010, when the National Green Tribunal came into existence with the passing of the National Green Tribunal Act, matters under certain provisions of the Act, like the Environment Protection Act, the Conservation Act, the Biodiversity Act, they got transferred from the Supreme Court to the. Accordingly, Almitra Patel's case got transferred from the Supreme Court to the National Green Tribunal. And the National Green Tribunal, in a very detailed order, in the year 2016, Lordship, I'll furnish the two orders of the Green Tribunal, gave 30 specific direction pan-India that these management rules were so important. The time period for which the state governments have to comply was within a window of 1 year and 5 years. Today we are in the 8th year. And the Supreme Court flagged certain, the National Green Tribunal, after the matter got transferred to the National Green Tribunal, flagged those issues. And one of the most important issues was that the solid waste management in the states, the Urban Development Department, along with the Pollution Control Board, has got onerous responsibility to carry forward the terms, the provisions of the Act. And accordingly, certain directions were issued, and those were told that they have to be complied, because if non-compliance takes them within the provision of the Environment Protection Act, the penal provisions, because the power of 716 provision rules were flowing from the Act of 1986. Then after this, the Supreme Court got an opportunity again in the year 2018, and there it could find that certain vector-borne diseases were taking place throughout the country, and the implementation of this Almitra Patel's direction were not being followed by the state government, as well as the central's monitoring under the Ministry of Environment and Forest. That's the reason I stated that three respondents have to be added now. Now, on that, the Supreme Court again took up the matter, and in the year 2018, on a matter, basically, I think it's a so motor matter, certain directions were passed. Lordship, I will just flag very important two orders of the Supreme Court. These are the two orders. It's reported in 2019-12 SCC 653. There, the Supreme Court could come to know that the states in India, majority of the states, have not developed their strategies or the policies as regards solid waste management.
Yes.
And they directed that penal cost should be awarded. And in fact, the Supreme Court also said that took judicial notice that 37,000 crores were already under the Swachh Bharat mission, for which paucity of fund could not be taken.
A reason.
Yes, a reason. And the central nodal agency, which is the Ministry of Environment and Forest, having powers coming from Section 5 of the 16 Act, needs to be given. They have to be now strict because the states are not complying. And the states are not complying to the extent, Lordship, I have an order of the Supreme Court, where in the year 2018, the Assam government was also called because they had not also given their affidavit. And as a result, the Department of Urban Development, Lordship, Urban Development Department Secretary was called. So we don't know as to what is the management plan for Assam, because the affidavits filed by the respondent in all the three cases I've checked up, 50, 74, and 38, only refers to the case that we have taken steps for Dibrugarh, we have taken steps for Sibsagar, we have taken steps for Nagaon. But they have not spoken about two very important sections. One is Section 16, which talks about a very comprehensive power being given to the Urban Development Department or the municipal administration to find out strategies and take up those matters with the State Pollution Control Board, because in the states, the State Pollution Control Board will be a monitoring agency. And the Central Pollution Court will coordinate with the State Pollution Control Board for effective management. Overseen will be done by the central government, because under the Environment Protection Act, Section 3, plenary powers has been conferred on the central government. So this is the mechanism. So my respectful submission is regards the three cases, three very important parties has to be added. The central government, I'm told by my learned friend, the additional CGS, he said that in one of the cases, the central government, that is the Ministry of, is a party. Necessarily, the other two parties has to be there in 38 and 50. Secondly, in all the cases of the Supreme Court and the National Green Tribunal, the Chief Secretary were being told repeatedly that we want compliance, we are not getting the compliance. So you will have to, the Chief Secretary of Assam will have to give a report as to what is the management plan, the management strategy, solid waste management strategy for the entire state under Section 16. And the second very important thing is that the Supreme Court has also flagged that under Section 23 of the Act, a state level advisory committee has to be there. Lordship, I've given the rules. Where the Section 23, all informal sectors, the rag pickers also, they have to be, stakeholders have to be taken into consideration. And whether, we don't know whether the state of Assam has complied with Section 23 of the Act. What you will find at Section 23 of the state level advisory board. Yes. Every department in charge of the local bodies of the concerned state government or union territory administration shall constitute a state level advisory board within 6 months from the date of notification of this rule. This rule is on the 8th year. The designations are very much given. Lordship will see, chairperson will be the Secretary, Department of Local Government, one representative of Panchayats and Rural Development, one representative of Revenue, one representative from the Ministry of Environment and Forests, one from the Housing and Urban Central Government, one representative from the Rural Development Central Government, Central Pollution Control Board, 8 is the State Pollution Control Board, the IIT, the Chief Town Planner of the state, 3 representatives from the local bodies, 2 representatives from towns and urban agglomerates.
There are around 17 members.
So it will be a very compact members, inclusive, And they will, Your Lordship will find that the state level advisory board will meet at least once in every 6 months to review the matter related to implementation of this rule, state policy and strategy on solid waste management, and give advice to state government for taking measures that are necessary for expeditious and appropriate implementation of these rules. The copies of this review report shall be forwarded to the State Pollution Control Board or the committee for necessary action. So basically, three very important parts are there to the rules. The Urban Development Department has to be a party. The second is the Pollution Control Board of the state has to be a party. The Deputy Commissioner has to be a party because Rule 11 talks about them, 12. And
Deputy Commissioner,
of each district.
he is this.
Yes, because he will coordinate with the Urban Development Department and the Pollution Control Board.
If we include the chief secretary,
Yes,
that would, I think so, serve the purpose.
yes, it will.
Instead of.
It will come, it should come from the top because this matter is very important.
Instead of implementing all the district.
No,
deputy
no.
commissioners as party.
Yes, and let them give a report. The first is what management policy for Assam they have under section 16.
They have filed the affidavit on the last occasion by the state in compliance of our directions.
Yes, there they have specified what steps they have taken.
Yes. So these steps which they have elaborated are not in accordance with this Act of 2016 or rules of 2000, this Environment Act, section 16 or rules of 2000.
Yes, Lordship.
Are not in,
No, they are not in because they have not specified what is the Pan-Assam management strategies they are going to follow.
or whether that this state level advisory body has been constituted. or
Yes,
not.
yes, well, because this is a question which is going up in the Supreme Court. Why not here, Lordship, the High Court?
Yes, no doubt. And that matter is pending with the Supreme Court.
Yes, Lordship, that is pending. In fact, there the council, the central government's, Assam government's council has made a statement before the Supreme Court. We are coming up with our plans. But a latter order I could not get. So if that plan is there, why can't they not put it here? Because your Lordship is seeing at the state level. In fact, Lordship is the,
Suggesting that the chief secretary, state pollution board, and
Lordship, the party will be the Ministry of Environment and Forest and Climate Change, central government. The second will be the Central Pollution Control Board. And the third will be the State Pollution Control Board.
central, second will be the Central Pollution Control Board.
Yes, Lordship, New Delhi. Because they will coordinate with the State Pollution Control Board.
State Pollution Board. Yes,
And then, Your Lordship, the Urban Development Department Secretary is not there, I've seen in some petition, because he is a nodal agency. Municipal administration is there, they will coordinate.
the chief secretary
Chief Secretary is a party.
in all the.
Lordship, I'll urge upon the Lordship that the Chief Secretary of the next date give a report, comprehensive report about the state policy in place. Yes, my lord,
बाकी क्या कर सकते हैं? नहीं बाकी दूसरा तो नहीं he is appearing
Chief Secretary of State.
नहीं 50%
38 and 74 percent. 74 on 9. 74 percent.
And in PIL 74 and 38, the Chief Secretary, Assam is not there. He has to be made a part.
He's also not there.
He has, in only one case he is there, that is item PIL 50.
This will cover. on 1/4/2024, this court requested Mr. V.K. Das to assist the court in these PILs, which are mainly filed by the petitioners raising a grievance regarding the mismanagement in the state of Assam on the issue of solid waste management. Stop. Mr. V.K. Das has graciously accepted to become amicus curiae in this matter, in these matters. He has submitted that the matter regarding management of solid waste management in the whole country is taken up by the National Green Tribunal in original application number 199/2018 and by the order dated 2nd of January 2017. Several directions have been issued to the state, to the central as well as the state government to take effective steps for the purpose of management of solid waste management in the country. It is submitted that the Honorable Supreme Court has thereafter took the matter in has dealt with the issue regarding the solid waste management in outrage as parents and life after child's dengue death and passed several directions to the states, to the central government as well as the state governments. To comply with the directions given by the NGT in its order dated 2nd of January 2017. So, the Net Council has pointed out that under the, which is that act you are referring to?
The solid waste management rules of 2016.
The act under the solid waste management rules 2016. Several responsibilities are given to the central government, central pollution control board, state governments and state pollution control boards to take effective measures for dealing with the menace of solid waste management. Full stop. It is pointed out that as per Rule 23 of the rules of 2016, every state has to constitute a state legal advisory body. It is also submitted that the Central Pollution Control Board as well as the State Pollution Control Board is required to supervise the management of the solid waste in the country as well as the respective states. Mr. Das has submitted that from the affidavits filed on behalf of the state of Assam, it is not clear whether any state level
The state policy on
state
solid.
level advisory body has been constituted or any policy has been framed
Under section 11
under section 11
of the rules, 2016.
under rule 11 of the rules of 2016. Stop. Mr. Das has submitted that in the pending PILs, the Central Pollution Control Board, State Control Board, State Pollution Control Board, Ministry of Environment and Climate Change, and the Urban Local Self Department has not been made party. It is therefore prayed that the above referred authorities be directed to be included as parties in this, in these writ petitions. Full stop. Taking into consideration the above facts and circumstances of the case, deemed it appropriate to include Ministry of Environment and Climate Change, Union of India, through its secretary, as party respondent. We further direct to include the Central Pollution Control Board and State Pollution Control Board. The Central Pollution Control Board, Assam State Pollution Control Board, and Urban Local Self Department through its secretary as party respondents in these petitions. It is also stated that in some of the petitions, the Chief Secretary of State of Assam is also
Not a party.
is not a party respondent.
PL 38 and PL
We
74.
direct that Chief Secretary of the State of Assam may also be treated as party respondent in the writ petition where he is not a respondent. Stop. The council, you are appearing for, Mr. Ministry of Environment, Mr. R.K. Dev Chaudhary is appearing on behalf of the Ministry of Environment and Climate Change, Union of India. Is, and Central Pollution Control Board. As well as Central Pollution Control Board. He may file his response by way of an additional affidavit on the issues raised by Mr. D.K. Das by the next date of hearing. The State Pollution Control Board is represented by whom? Yes,
Mr.
S.
She's not a-
You are for the,
He's standing on the.
he is standing counsel for. The state, Mr. S.D. Barua, standing counsel for the state pollution, is the Assam State Pollution Control Board, is directed to accept notice on behalf of the said respondent. Urban Local Self Department.
To the state petition.
Urban Development Department.
He will, urban local, urban development department.
Urban Development
Development,
Department. You, ये यहाँ पे लिखा है। Mr. So and so is appearing on behalf of the, Dinath is appearing on behalf of the Urban Development Department. Urban Development Department. Government of Assam. The Council for the State Pollution Control Board as well as the Urban Development Department, Government of Assam may also file an additional affidavit regarding the issues raised by Mr. D.K. Das by the next date of hearing. Then it, council appearing for the petitioner may file the amended cost title, including the newly added respondents within a period of 2 weeks.
Milord, may I pray one thing, Milord? Milord, I am also appearing as an amicus in this matter because original petitioner wanted to withdraw, so I later came on. Can it be a direction to the registry to
complete them.
Yes, the inform.
See how the registry will do it.
All right,
Some
my lord.
page-
Fine, fine, my lord. Fine.
The Economic Development Department, now it is renamed as Housing and Urban Affairs,
Housing and
Urban Affairs.
housing and urban development, housing and urban affairs.
Urban.
Does this matter? Does this matter on? Fifth of August. 5th of August.
Yes, 74.
Get it done from the other parties, service, you get have the copies from the other parties.
Item 4.
Sir, you have not filed the affidavit regarding the service of respondent number 7.
Yesterday I have filed, my lord, but there was a defect in the affidavit because I could not start on copy on the rest number 6. I have the Rest number 6, no, wait, I don't know.
6 minus 7 it.
No, it is 7, 6 or 2.
Four, 5, 6, 7. Title is 7.
No, 7 or 2, 6 paper. It
What's the
is,
defect in the affidavit?
sorry, my lord.
What are the defects?
Well, I could not start copy on the respondent number 6, my lord. Council for the respondent number 6. That is why it is in defect, my lord.
Asifa Ahmad.
For respondent number 6, one Mr. Upadhyay is appearing, my lord.
Council for the council for the respondent number. Respondent, you are for the respondent?
I am but a state, my lord.
State has submitted that he has already filed an affidavit regarding the service of notice upon the respondent number 7. Full stop. The same is not available on record, however. Mr. Katniar has shown us the copy of the affidavit filed on behalf of the state. From the same, it appears that the notice upon the respondent number 7 was personally served on 4/4/2024. In such circumstances, we deem it appropriate to treat the service upon the respondent number 7 as complete. Office is directed to tag the affidavit filed on behalf of the state regarding service of respondent number 7. Along with this file. When? Just after 2 weeks for admission.
Obliged,
Obliged.
Admission, it's a matter of condonation of delay.
No.
The matter is. Acha, that is writ appeal. That's, yes.
Yes.
Writ appeal.
Obliged.
Item number 5.
Yes, Mr. Congress.
Lordship, earlier it is
SFB was dismissed.
dismissed,
shall be
Lordship, and
dismissed.
thereafter, Lordship, the government also proceeding to implement the order passed by the Lieutenant Single Judge. Only thing is, Lordship, AGCC has been closed down. Though I have appeared for the AGCC on last occasion, earlier occasion, they kind of filing the appeal. Now AGCC has closed down. That is why Lordship has directed the government advocate to take the instruction regarding this appeal, Lordship. I cannot withdraw also. Last occasion, she was directed to close down. I'll be bored, I used to take instructions. No.
The SLP lordship, some process has been initiated. after.
SLP dismissed, my lord. There are two read appeal filed against the same honorable single judge judgment, my lord. One is, my lord, decided by this honorable court. Against that, they went to Supreme Court and Supreme Court dismissed. Now, this case is pending, my lord, because another read appeal is pending.
This case is pending before the Supreme Court.
This case is pending before the this honorable court because there is a delay. Two appeal filed against the same honorable single judge order, my lord. So one is disposed of by this, one read appeal is disposed of by this honorable court. Against that, my lord, they have went to Supreme Court, my lord. The Supreme Court dismissed, my lord. Now, my lord, nothing to decide, my lord. So these are the order.
This is covered by the other.
Lordship, understand.
These are the judgment. The same party, Assam government.
Where is the other order?
My
of the
lord.
Division bench.
Yes, I have division bench order, my lord. This is Manojit. Read it 342, my lord.
Single bench order is dated
Dated, my lord. It is dated.
15/12/2012.
18/4/17.
Huh?
18/4.
That is 18th, my lord.
I have given copy.
Did he?
Yes, I have given a copy.
That is 25/7/2017.
Lordship.
27/3/2014. This is the single bench judgment.
দুটা appeal file হৈছে নহয়, এটা review file হৈছে, আমাৰ কৰিলে recursion file এইটো এইটো পঢ়িলে এইকেইটা আমাৰ নহয়, আমাৰ প্ৰশ্ন উত্তৰটো যোনটো review কৰিছে থাকে।
But where is that order of division bench? There are. Where is the order of division bench against which the SLP was filed?
Against that order.
25/7/2017.
25/2007.
That is state government.
And the single bench judgment is dated.
27/3/2014, my lord,
And
the original judgment.
In that, this appeal which was dismissed.
Read appeal 342, my lord.
My lord, in
342 decided on the.
Mr. Borgoy, why simple answers you are unable to give?
My lord, there has been little minor confusion because, my lord, the original order of Honorable Justice Ujjwal Bhuiya, my lord, was reviewed, my lord. It was reviewed and review was dismissed. Review was done by the state. So that is number one. Similar cases were filed by other employees, which we were not part. And those cases, my lord, the state has gone for appeal. And those writ appeals are, my lord, those writ appeals are, my lord. Yes, those writ appeals are, my lord, writ appeal number 159 of 2015 and writ appeal number 342 of 2015.
But the concept of the parties are in agreement that the controversy involved in this is already set at rest by the dismissal of the SLP referred by the Assam government for Assam Government Construction Corporation Limited before the Honorable Supreme Court. An order passed by the Honorable Supreme Court on 7/11/2023 in special leave to appeal number so and so, you get it done in hand. Special leave to appeal is placed on record. In view of the joint statement made by the counsel for the parties, the writ appeal number 115/2017 is dismissed. The IA number so and so for condonation of delay is also dismissed.
Item number 7.
Right, Your Lordship. On previous occasion, respondent number. Bank. 5 and 6.
Yes.
Lordship, I appeal for the respondent bank. I have obtained the instruction, Your Lordship. As per the instruction, the petitioner is receiving his entitled.
Okay. When the council, Mr. So operating for the respondent number 3. Sorry, Mr. You are S. Burgaon. Mr. S. Burgaon, the council appearing for the respondent bank.
5 and
Submitted 60. Respondent bank has submitted that the petitioner is getting full pension as per the revised PPO, issued revised PPO. It is submitted that a affidavit in this regard will be filed within a period of 2 weeks. Within a period of 2 weeks. So 2 weeks is granted to Mr. Burgaon for filing the additional affidavit. Just after 2 weeks.
Item number 8.
Actually, I sought for adjournment for today, my lord. Otherwise, my lord, respondent 8, my lord, has filed an additional affidavit, my lord, bringing new facts, my lord. Earlier respondent 8 was not a party before the honorable single judge. Now the respondent 8, my lord, in paragraph number 6, page 110, have stated that, my lord, the fund was already released in the year 2014 to the NC Hills Autonomous Council. And they have already utilized the fund.
Utilize the fund.
Yes, but so far the petitioner contractor, my appellant is concerned. He has completed the work in 2015. He built a public road, my lord. But while passing the order before the honorable single judge, my lord, they have misrepresent the fact, saying that supplementary demand has been made, no budget is there. So as and when fund will be given to them, in paragraph 4, they have stated they will release it. That is contrary, my lord. Now, the respondent eight, implemented respondent eight has finally, my lord, said that fund is already utilized by the NC Hills. And because of that, my lord, till 10 years gone, my lord, the appellant has not got a single money from the,
They have admitted your claim.
but that is what, my lord, paragraph 4, page 20 of the single judgment, my lord. It is only a submission.
Ultimately, the learned, single judge has given a direction that if the claim is admitted, the respondent authority will process the claim of the in accordance with the light of the direction contained in so and so.
Paragraph 4, may I read, my lord?
Yes.
Page 20. Referring to the averments made in affidavit in opposition filed by respondent 3, Mr. Das Lanet Standing Council, Dima Hausa Autonomous Council, has submitted that it has been admitted that a contract work had already been completed. The total value of the contract work executed by the petitioner is also not disputed. For making payment to the petitioner, a
So they
supplementary.
said, whenever the fund is received, we'll make the payment.
That is the thing, my lord. Fund was already paid to them in the year 2014.
And now what is their standing?
Now your lordship will kindly see the respondent 8 affidavit.
Who is the respondent?
This is the Hill Area Department, my lord,
What
secretary.
he said?
He is the concerned authority who released the fund to the NCH. Paragraph 6, my lord.
Yes.
That in this connection, information on Hill Area Development Program scheme is sought from Development Commissioner for Hill Areas, Assam also. Information received from Office of the Development Commissioner of Hill Areas, Assam, that rupees 6693.30 lakhs was released to both Karbi Anglong Autonomous Council and NC Hills Autonomous Council as installment, including matching state share during 2014-15 under HADP. My scheme is also under HADP for the relevant area. It may also be stated that both Karbi Anglong and NC Hills Autonomous Council submitted their respective utilization certificate against the aforesaid release amount, which were also forwarded to NITI Aayog, and the same will be intimated once it is received. Now, this fund was already sanctioned and released and utilized, but their stand is that the supplementary demand has been made till now, my lord. From 2019, they say, 2019, when the writ petition was pending, my lord, they say supplementary demand from the state government was made. Whereas entire fund was utilized by the NC Hills, my lord. This is a, my lord, while disposing of the writ petition, this fact was not there, my lord.
Which is the authority who is responsible to make the payment?
My lord, principal secretary, my lord, NC Hills. That is respondent number 2 and 3, my lord.
So now they have already said, okay, we have already disbursed, then what remains?
Para 4, your lordship will commission.
Yes, how much time will you do?
My lord, I have to obtain instruction only 1 week, my lord.
2 weeks.
Can it be fixed on a date, my lord, because,
You ask the court master, he'll fix it.
my lord.
Item 9.
Lord, in this appeal, kindly give me 1 day time. Lord. Today itself, Lord, there was some Lord, confusion on our.
Do not,
I'll take this
appeal
back
for
today.
the state, place some more time, to take fresh steps
Lordship. By today, I'll.
for service of notice upon the respondents.
1 minute, Lordship.
Template for it, this time.
But- The interim order is there, Lord.
Interim order, if I need to continue till next page.
Lordship.
Item 10.
May I put your lordship? My lord, in this case, my lord, the respondents by the affidavit, it is stated that they offered a grade 4 post to the appointment.
Have you filed any review application?
No.
Lordship, actually, Lordship, yesterday we got some instruction that the petitioner might accept the grade 4 post. Otherwise, Lordship, review petition is
My lord,
ready.
I have already talked to my client, my lord. In heavy heart, he has accepted this offer, my lord.
Heart, what
Yes,
do
my
you
lord.
mean by
My
heavy heart?
lord, since this one got directed to grade 3, my lord.
In today's time, if you are getting whatever the job,
My lord.
government job, please accept it with grace.
Yes, my lord, I am ready
With
to accept
heavy
it, my lord. Only my prayer, humble prayer before this court. My lord, since I'm physically handicapped admittedly, my lord, and having my 90 years old mother and 2 elder unmarried sisters, my lord, it's my humble submission. If they accommodate me in my home district, that is my only prayer before this court. I'm ready
The
to
rule
accept.
permit, certainly they will,
You know,
if the
so-
rule doesn't permit, then how can we ask them
My lord,
adjust them?
That
in
may be
the-
taken.
my learned friend, I already told my learned friend, my lord, Mr. Nayak, my lord, on yesterday, is I'm accepting their offer. my lord.
He is willing to accept grade 4.
Yes, lord, that is my standing the
Give him in his home district.
Yes,
because of his,
that will,
yeah, no.
it will depend upon
Give it.
vacancy availability. That is the one. Lot of
But grade 4 says home district ही होना है. बाहर नहीं दे सकते.
Bring order on the record. कब देंगे आप? When you will provide appointment to him?
Lordship.
When you are going to provide
Lordship
appointment
will,
to him?
Lordship, up to 4th of June, Lordship MCC is there. Lordship will grant me 3 months' time, Lordship. Within that period, we will make a.
Month's time? 4th of June.
Only
model
because
code
of
MCC covers court also. Court order is
Court
also
issues.
covered.
They will say,
Yesterday they have
we have
produced
to
the
make an
appointment order.
application to them. They will say that court has not passed any order to us, Lordship. That stand they are taking in some cases, Lord.
Sorry?
Election Commission, Lord.
What do you mean by election commission is not party and we are not bound by the election
That
commission?
is.
Whatever the MCC is
Only
there.
because of the
court-
MCC, I'm praying for some question.
Yesterday, some appointment order was issued and it was placed on record in contempt matter only.
Otherwise, Lordship, yesterday
Learned
evening.
counsel for the learned counsel for the petitioner has submitted that the petitioner is ready to accept the appointment on the post of grade 4, bracket mein MTS. He has submitted that he has already conveyed his desire to the, he has already conveyed his willingness to accept the appointment on the post of grade MTS post to the respondents. Full stop. Learned counsel appearing for the respondent has also admitted that the petitioner has the petitioner is agreed to accept the appointment on the post of grade 4 MTS. Full stop. In such circumstances, we deem it appropriate to direct the counsel for the respondent, Mr. P. Nayak, to produce the appointment order before this court by the next date of. Here, produce the appointment order of the petitioner on grade 4 MTS post by the next date of hearing. Put upon.
At least 2 months time will be granted.
Not 2 months.
Any date after 4th of July.
Not at all. Not at all. This is what MCC has no business with the court's orders.
You are bound to comply. Election Commission has nothing to do with this. Election Commission is not an authority above the court, Mr. Nayak.
Then
Election Commission has supremacy only in matters of election.
Lordship, after
When the
4
court passes an order, you are bound to comply with it.
10th of May,
Lordship,
10th of May.
not this month, Lordship. Lordship will gain.
Why
grant
not
you
this
4
month?
weeks time.
Why?
Lordship.
Failing which the respondent would remain
Why?
persecuted.
On 10th of May,
16th.
failing which
16th.
15th of May, full stop. If the appointment order, if the appointment order of the respondent number 4 is not produced, the responsible person shall remain present before this court. अब हो जाएगा.
Item 11,
Mr. Nayak, what is this confusion about Election Commission? Election Commission Model Code of Conduct applies to the political authorities. You are not supposed to make any poll promise. Does it cover the courts, high courts also? Is that the understanding of the government?
Not of the government, Lordship. So far as appointments are concerned.
Appointments, you inform them, that's all. You have to comply with the order of the High Court. Election Commission has absolutely no business in this. And please don't come up with that argument in any other case. When there is a court order, you have to comply. This is not a poll promise made by anyone. The Constitutional Court's direction has to be complied with. The Election Commission of India has no business in these matters. That is the constitutional scheme. They are only to conduct the election, and conduct of election should not be interfered with. That is the only mandate in Constitution, nothing else.
Not, it will be complied.
Yes, my lord. It is- This picture referred.
Yes.
Yes, I have received the instruction from the sole contender. The direction to make the payment for area salary for a terminated period, my lord.
Yes.
And that terminated period has to be regularized, my lord. Therefore, director has sent the proposal to the government. But the problem is that here, my lord, the secretary is not the party in this contempt proceeding, my lord. Director is the only party in this proceeding.
Who is going to, who is the person responsible for releasing the areas?
Director will send the proposal to the government for sanction the amount. But before that, my lord, the termination period, that period has to be regularized. That will be done by the government, my lord. So director has sent the proposal for regularization to the government.
This is a mistake. Mistake of the petitioner, and it's a mistake overlooked by the Indian bench. He has to file the correct thing. So unless he is regularized. No. नहीं ये है ना ये स्टेट और कमिश्नर सेक्रेटरी
Who is going to regularize the services?
Government, madam.
Government, which authority of the government?
Secretary, madam.
Secretary. The state of Assam represented by the commissioner and secretary of the government of Assam Education Department. He was party to the petition.
In the contempt proceeding, he is not party, madam. Proposal has been sent to the secretary, madam.
No, but
in Britain,
Permitted to implement, because lordship specific direction was to the director.
demand compliance and then.
We did not submit the certificate copy also before the government.
Mr. Katnia is appearing on behalf of the full respondent, it is submitted that this court has issued in direction to the director of secondary education Assam to take necessary steps to release the areas of salary of the petitioner and process the same for the period from 21/5/2012 to 18/1/2014. It is submitted that for the purpose of releasing the areas of salary, the services of the petitioner for the aforesaid period are liable to be regularized, and in that view of the matter, the respondent has already referred the matter to the state government for regularizing the services of the petitioner for the aforesaid period, and the same is pending at the level of the state government. Full stop. Taking into consideration the fact that the regularization order of the services of the petitioner is required to be issued by the secretary, commissioner, secretary and commissioner, what is the?
Now it is secretary, my lord.
Huh?
Now it is secretary, my lord.
Secretary of the Government of Assam Education
Department of School Education.
Education Secondary Department. We direct the respondent, the petitioner to implead the said authority, implead the said officer who is holding the post of secretary of the medical so and so within a period of 1 week.
Yes, sir, वो पहले demand करना पड़ेगा. We used to call demand contract. Contempt of contempt.
We directly,
Can't liberty. Yes, demand, they might comply with it. Secretary might comply with it. What I'm saying is. Yeah, it's saying, it's saying contempt. Here's the demand supply to all people. And then. So. Contempt activate over when he refuses to come. अभी जो हम इंप्लीट करेंगे इसलिए ये नॉट डिफाइड द कोड ऑफ लॉ तो इसको पता ही नहीं है मान लेते ना इसमें डिमांड ही नहीं करता It is the obvious. I mean, you can jump it. But if you want to jump it, you can do it.
The secretary has to comply with the. No, full stop. In such circumstances, we grant liberty to the petitioner to approach the secretary, education so and so with a prayer to regularize this service for the period running from 21st of May 2012 to 18/1/2014. Pursuant to the recommendations made by the Director, Secondary Education Assam dated 30th of April 2024. Stop. The petitioner may approach the said authority within a period of 10 days. List after 2 weeks. You approach them within 10 days, and if is not responding, then you plead him as a party.
Oblige.
Item 12.
Well, the order has been complied with, I am punishing the speaking order. The claim of the petitioner has been rejected. He was found to be unauthorizedly absent from February 2014, not to speak of his service in 2017.
No, my lord, actually, yes, my lord, filed repetition, my lord, earlier repetition, my lord, is for salary. area salary.
What is the direction?
Yes, Lord, we will find that, my lord, in the relevant part will be page 29.
Page
29 of the contempt petition.
29.
Yes. In the order, my lord, the order of the learned single judge has been quoted.
We are in total agreement also made by the enterprise corporate. The appeal is being of merit, deserves to be dismissed. And accordingly, the same is our even. While dismissing the appeal, we make it clear the respondent shall adhere to the direction learned single judge in paragraph 20 of the judgment. If any representation is filed by the appellant or any financial remuneration shall consider the order by the learned single judge. What's the order of the learned single judge?
That is
Page 29, madam.
Page 29 is the
page 20, paragraph 20.
It has
my
been
lord.
quoted, madam.
Quoted.
Yes.
From such point of view, it is
Yeah,
reserved
from
that in no
18
respect
madam.
to the liberty is granted to the petitioner for appropriate representation. He may enter to provide the petitioner can make out the appropriate representation. In that representation, the respondent has as a reasoned order on entire.
Kindly peruse your lordship, page 19, paragraph 18, my lord. Honorable single judge.
If he has any grievance, he will have to challenge it, madam. There is a fresh cause of action.
Yes.
During the pendency of the repetition, I have come to know that I have been terminated, my lord.
Whatever it may be, this is the order, the court has given a direction to decide your representation. They have decided if you are aggrieved, you can challenge it.
Yes, with that liberty, my lord.
Typical and a concept of the respondent has submitted that since the representation of the petitioner has already been decided by a speaking order dated 30th of April 2024. Substantial compliance of the order passed by this court has already been done. Learned counsel appearing for the petitioner is not in position to dispute the fact, hence not dispute the fact in such circumstances when the order passed by this court has substantially been complied with. No further order is required to be passed in this contempt petition. The same is therefore dismissed. Notice is discharged. However, the petitioner is at liberty to avail appropriate remedy if he is aggrieved by the order by the speaking order dated 30th of April 2024 passed by the respondent.
Item 13.
The appeal, my lord, is a state, appeal by the state, my lord. The, against the order passed by learned single judge, my lord, there's a delay of 73 days.
Who is appealing for the respondent?
I am for the sole respondent, my lord. My lord, I have no objection, my lord, due to this conduct. I think, my lord, some
You are appealing
urgency.
for all the respondents?
Only one sole respondent, my lord. There is one.
One?
Yes,
Only
there is a repetition available.
And what, only one respondent is there?
Yes, my lord.
73 days. 73 days.
Only prayer, my lord, the appeal may be listed within 2 weeks, my lord. Some urgency.
Yes,
from
yes,
one
yes,
side, my lord.
I have
By
nothing.
promotion
The
and
matter
conduct.
comes upon for consideration of the IA number so and so with a prayer to condone the delay of 73 days. So, the concept of the sole respondent has no objection if the delay is condoned. Having heard the learned concept of the having gone through the contents of the application, contents of the IA, we deem it appropriate to condone the delay of 73 days in filing the appeal. The IA is disposed of, connected it within, registry is directed to register the connected writ appeal. And to register the connected appeal and list it for admission on
Any day convenient to download. Court, my lord.
13th of May.
Mine. Obligation.
Item 15.
Look, here, Milord, our report has not come. Kindly allow us,
Item.
so we have to take a fresh steps to the restaurant one.
Which report has not come?
We have taken dusty step, Milord, but
Await return of notice of respondent number, sole respondent. For
One.
3 more weeks.
Item 16.
In 16, services company, Milord, we have filed the affidavit.
But here, a penny,
I'm a big
that is compassionate upon.
Compensation amendment, Milord. IA for delay of 173 days. Milord.
Yes. What do you want to say?
See, there is no explanation, Lordship. It was a filing.
But in fact,
The chamber, Lordship.
in identical appeals, we have already.
Lordship, that is the Lord.
Okay. Matter comes upon for consideration of the IA number. So and so, with the prayer to confirm the delay of 171 days, then a concept of the appellant. The applicant has submitted that in identical appeals, this court, while condoning the delay, has already admitted the writ appeals, full stop. Then a concept of the respondent has opposed the application for condonation of the delay, having heard the learned concept of the parties and after going through the contents of the application, we deem it appropriate to condone the delay of 173 days, 171 days in filing the connected appeal. IA is disposed of, registry. It is already registered.
No, Milord. Now appeal will be
Registry
done.
is directed to register the connected appeal and list it for admission after 10 days.
Obliged.
Hold on.
Item 17.
Yeah, please, Your Lordship. In light of the earlier order, Your Lordship, no copies were served.
For the respondent.
And for the.
Petitioner is absent.
Who is for the petitioner? Gogoi.
Gogoi, Lordship.
But then password for the time.
Item 18.
No
Make this-
counter affidavit has been.
I have filed my affidavit.
When?
Mala today morning, Mala.
So,
My lord, I pray 10 days time for rejoinder affidavit.
Mr. So has submitted that the counter to the writ petition has already been filed. Then concept of the respondent phrase, 10 days time to file. To file counter to the reply file on behalf of the state, on behalf of the respondent. in the stop of 10 days.
That's blessed.
Item 19.
Please, my lords, I beg to appear for the petitioner in this matter through VC. This is an application for condemnation of delay in filing the writ appeal, my lords. There is a delay of 53 days. I was not a party in the writ petition, and I've sought leave to file an appeal as well along with this writ appeal.
Where is your application for seeking leave to file appeal?
No, my lords, this is an application for condemnation of delay,
Madam,
which is
without-
listed today.
Without even seeking
Well, there is a-
leave to file
Please,
appeal,
ma'am.
how can we condone the delay?
My lords, even that application is there, IA number 2871 of 2024. That IA is also there, ma'am.
Okay, list this application along with IA number.
Yeah, already listed.
Listed here, it is listed.
2871.
Okay. 2871.
Please, my lords.
Filing number is not registered, you mean to say?
Not registered. It will be registered in the system. It will be registered in the system.
Okay. The matter comes upon the consideration of IA number 1194/2024 and IA number 2871/2024. IA number 2871/2024 is filed. And the applicant seeking leave to challenge the order dated 12/12/2023 passed by the learned single judge in WPC number 73/2016. The said IA is not registered till date. We are of the opinion that before considering the IA number 1194/2024 seeking condonation of delay in filing the connected appeal, the IA number 2871/2024 seeking leave is required to be considered. Hence, registry is directed to register the IA number 2871/2024 and list the same before this court after 10 days.
Much obliged.
Item 20.
Twenty-two days. Well, there is delay of 22 days.
Yes, what do you want?
Lordship, short notice period maybe. Short notice period, Lordship.
Notice to whom?
Lordship to the state, because I have to, I may have to file an objection, Lordship.
You submit your objection, we'll consider.
Lordship, in another case of arising from the same judgment, notice has been issued, Lordship, for
IA.
in the IA.
Confirmation of delay.
Yes,
How
Lordship.
many days delay? was it?
22 days.
Same.
Same days.
But since I think so in that you were not
I leave
appearing,
it.
now you are appearing.
Lordship, I appeared in that.
You appeared in that.
Yeah.
We'll connote the delay. The matter comes upon for consideration of the IA number so with a prayer to condone the delay of 22 days in filing the connected appeal. Then a counsel appearing for the respondent has opposed the application. Having heard the learned counsel for the parties and after going through the contents of the application, we deem it appropriate to condone the delay of 22 days in filing the present appeal. IA number so and so is therefore allowed. Delay of 22 days in filing the connected appeal is condoned. Registry is directed to register the connected appeal and list it for admission
After a week, my lord.
after 2 weeks.
Well, deep level.
Item 21.
May it please the Lordship. There is a delay of 112 days, my lord.
Who is appearing for the respondents?
I appear for respondent number 3, my lord. I have no objection.
This is basically against
Respondent 1, my lord.
Respondent one.
Otherwise, we'll be supporting the appellant.
Who is appearing for the respondent number 2 and 4?
2 and 3, I'll be appearing, my lord.
2 and 3.
2 and 3, you are appearing.
No, I am for 3, my lord.
And then I'll be 2.
4, accountant general.
I know, sir, 3.
लिखिए, notice is to whom? Notice is to
The
issue notice of the IA number so and so. Mr. So and so put an appearance on behalf of the respondent number 1, respondent number 2. Mr. So and so put an appearance on behalf of the respondent number 3. Mr. So and so is appearing on behalf of the respondent number 4. Let notice be issued to the respondent number 1, returnable on charge.
I can take dusty service, my lord, because R1 is from here
Registered
only.
AD, that's the registered AD.
Fine, fine.
For admission, item 22 and 23.
Maybe there are. But looking into the
First of all,
problem,
congratulations on completion of 50 years. I'm
No,
sorry
I-
I was not able to attend.
well, if I may pray, but prefer not keep. But for withdrawal of the writ petition itself,
For
withdrawal of the writ petition itself,
withdrawal.
withdrawal of the writ petition itself.
We must withdraw the petition.
Lordship, if I may highlight your lordship, there are three.
Do you have any objection in withdrawal of the writ petition?
No, I have not. But the lordship, I thought it prudent to highlight one aspect, your lordship. There were three writ petitions pertaining, which may have a bearing to this matter, your lordship, which was heard on 25th of this month, and judgment was reserved, your lordship. If I may just place the order of it, I have no.
The writ petition was dismissed
Oh, it's
without
already-
considering the merits solely on the ground that the earlier writ petition was filed and 25,000 cost was imposed. Now he wants to withdraw the writ petition. What remains? This cost will also go.
Yes.
Cost is it. Cost is it. To make it cost.
Which is it?
Then
Oh.
concept for the appellant is submitted that writ petition.
He wants to withdraw the writ petition.
And concept for the appellant is submitted that he wants to withdraw the writ petition number 6854 of the 2023, which was decided by the Learned Single Judge on 29/11/2023, whereby the writ petition has been dismissed with a cost of rupees 25,000 on the ground that
Our.
earlier a writ
7298
petition in the
now?
name of the same petitioner has already is pending consideration.
Yes.
Is pending consideration. Full stop. Learned concept of the appellant has submitted that as a matter of fact, the appellant has preferred writ petition number
7298.
7298/2023 bona fidely without knowing that earlier writ petition in the name of society is already filed and pending consideration. So, when concept of the appellant has submitted that he has no intention to mislead the court. Full stop. Having heard the learned concept of the parties, and after taking into consideration the submissions made on behalf of the concept of the appellant, we allow the appellant to withdraw the writ petition number 7298/2023. He were ordered accordingly. The appeal is disposed of. Cost imposed by the Learned Single Judge is made easy.
Much obliged.
So far as the second writ petition is concerned, that's W6854, that may be taken up by honorable anyway.
Yes, yes.
6894, it is.
That was called for.
List, writ petition number 6854 of the 2023 before the appropriate course.
My lord, I am indebted to your lordship for your lordship's words, lovely words. Otherwise, I could not.
Object.
Item 24.
May it please your lordship.
Throat. Yes,
My lord,
just a
the lordships.
Yes.
My lordships. Lordships have gone through. The small crux is whether the executive, the government can choose to selectively comply to directions of the court. I agree that two things were there. By one, the promotion was given with all consequential benefits from 21. That order was passed in 24. I also concede that they were given handle liberty that should you believe of things that we are not eligible or modify or otherwise, then kindly issue show cause notices. We both did not come in appeal. Therefore, the order I think is a final. Now, how to comply?
Without reinstating them or without
Absolutely.
granting consequential benefit straight away on 12th of February, they
Absolutely.
have issued this notice.
That is
Why you be not promoted for so and so.
Correct.
But the learned single judge order was there that from this
It is on the premise.
revocation order was already cancelled. Then they have to do a fresh exercise. Yes, Mr. Without reinstating them or granting any benefits regarding promotion, how can you?
Paragraph 8, madam.
Paragraph
Paragraph
of
eight.
what?
Paragraph 8 of the judgment. Paragraph 8, which is the parent judgment. There are two judgments, my lord. And paragraph, page 48, my lord.
48. Yes.
It has been held, my lords. On merits also, it has been held.
Read.
Yes, my lord. After careful scrutiny of the so-and-so rules of 2005, I do not find any provision which permits forest guards completing 3 months training to be promoted in the next higher rank of forester grade 1.
Moreover, even it is assumed that other forest guards are eligible for promotion. The promotion already given to the petitioner notified the company authority could not have been revoked in this fashion without giving an opportunity of being heard to the petitioners. Under the circumstances, but this court is of the unhesitant opinion in the order that is so and so is not only illegal, but same is also a violation of the principle of natural justice. So whether the upper part, well, for there is also a whisper in merits, my lord. That they are not, the rules, perusal of rules also indicate.
Maybe the learned
My
single
lord.
judge has allowed the writ petition in the ground. Even though if the promotion orders are not in accordance with law or they are not entitled to be promoted. But you can't revoke that promotion order
Yes.
in the fashion in which we have done.
No.
And therefore, the orders are set aside. With all, the petitioners are entitled to all consequential benefits. And thereafter, if you feel that they are not eligible for promotion, issue them a notice and grant them opportunity of bringing them that pass order. Not state where this order is the first of February 2024. When you reinstated them on the promotional post and got the consequential benefits, if you are aggrieved by that, should have challenged this order.
We went with the paragraph 10.
Yeah. So,
My lord, what I pray,
that's
my
why
lord,
only is rightly
what
said,
I
that
pray, my lord,
collectively you can't choose the compliance of the order. Para 9 is also very clear, but you are asking upon para 10.
my lord,
What is this?
I will ask for a limited notice. Let this petition be heard on merits because our affidavit was ready.
First of all, comply with this order, otherwise we are going to
My lord,
stay that order. First you place an order of reinstatement.
Yes.
Consequential benefits, then we'll hear this appeal. That's all.
And then,
No, you can't choose both the things. If you are aggrieved, should have challenged this order.
my lord,
You have not challenged that order and you taken this bypass now. Not perfect.
and then that this writ petition be allowed in limited terms, my lord. Otherwise, then after
Yes,
granting, my lord, my lord, after granting the benefits also will be at liberty. my lord.
Absolutely. Correct.
Sure.
Yeah, sure.
Yes,
Certainly.
he is accepted. That may be noted, my lord.
I
After granting
cannot
the benefits, my
accept
lord,
or
we
not
will have
accept.
liberty.
It's an order of the court. I have
There is
chosen
no
not to
question
challenge.
of his acceptance at all. This
I know, my
court
lord,
order is
because
not
this,
dependent upon his
my lord,
acceptance, sir.
these petitioners, my lords, these are busybodies only, my lord, clamoring with litigations.
That's
That is the
personal.
reason I'm saying, my
That's
lord.
personal, Vinod. He's being personal on my
Not on
client.
him, not on him.
No, no. Sir,
Well, we'll grant the benefits, we'll comply with the court's order, but we'll also be at liberty to,
that liberty is already there.
yes, my lord.
That liberty
Yes.
is already there.
Yes, my lord.
Comply with person order.
My lord.
Okay.
We'll comply with the order.
You can't make this order, issue notice. Learned counsel, Mr. So and so, appearing on behalf of all the respondents, you are appearing for the, all the respondents.
And for the, all the respondents. Two respondents. only.
Do this.
Principal Chief Conservator. Environment and Forestry Department and this Principal Chief, you are appearing for all, both of them.
I'm for the both.
Okay, issue notice. Then council appearing for the all the respondents, Mr. So and so, accept notice on behalf of so and so, service is therefore complete. In the meantime, the respondents shall not pass any final order. In response to the notice dated 12/2/2024 till next date.
And
Well, yes, they have not replied also till now.
Just a minute.
Tendency to reporting would not be a bar for the department. It was consequential order, in complete compliance with the order.
Our liberty is granted to the respondents to pass consequential orders
In complete compliance.
and in complete compliance of the order passed by this court on 1/2/2024 in WPC number 5299/2022. We pass an order
Yes,
and thereafter will allow you to kind of go with the.
always.
Item 26.
Due to mistake of my, my lord, the copy has been served today, my lord. It may be any other day.
Not just now, my lord, I got the copy of the writ appeal and the stay petition.
Yeah,
My lord, some short date, my lord, any other date.
what's the problem?
My lord,
My lord, copies of the writ appeal as well as the stay petition I got here only a little ago.
Okay.
So that's why
any
I
other
couldn't
date, my
go
lord.
through.
Okay, then council pending for the respondent. I submitted that. Respondent number? Your
Private respondents will not, I have to know, huh? 4 to 29.
4 to 49.
Yes. 4 to 29.
4 to
29.
29.
4 to 29.
4 to 29 I submitted that is in receipt of the is in receipt of the record of the appeal. Today only, he placed some time to complete his instructions. List on,
Could it be on 9th of May, my lord?
9th of May, yes.
9th.
9th of
Item 27.
Here the petitioner challenged the impending order dated 5/4/2023 passed by the learned Armed Forces Tribunal OA 8 of 2023, whereby the second service family pension was allowed. In fact, the respondent's husband has not completed the mandatory 15 years second service model. He has completed the first service period. Thereafter, he was enrolled in the second service at DSC. There he has completed only 14 year, 3 months. So there is specific provision, Malot, under the pension rule, Malot. Second service pension, Malot, there is no provision for condonation because he has, and the respondent has already availing the first service pension. So in the similar facts and circumstances, Malot.
Well, notice of the writ petition as well as the IA stay petition, returnable stay petition, though you have not filed.
Malot, in the petition, there is a pair for interim pair, Malot.
Interim may be notice on the issue notice of the stay application as well as the
interim prayer.
Interim prayer, issue notice of the writ petition as well as of the interim prayer, returnable or.
He is from which state?
Malot, here, Malot, Assam, Malot, in the similar facts and circumstances, my pair for lawsuits, the Assam High Court, as well as the Supreme Court, the matter is pending, there is a stay, Malot.
Let the notices be served. She is widow, he want that.
This is the second service pension, Malot. She is availing the first service pension, Malot.
I understand, sir.
Malot,
I understand.
similar issues are before the Supreme Court also, there is a stay, Malot.
Yeah,
And
we
the
understand, but
and Rajasthan High Court, Malot, this same issue, Malot. Malot, same issue, Malot. You also closed it.
if you are doing this, we are not going to pass any ex parte interim stay order. We are simply saying, let the notices be served and we'll consider your.
Malot, that is why my prayer for lawsuit, kindly look into the orders.
In the issue notice of the writ petition, the prayer for interim ex parte stay is rejected at this stage. The prayer for interim order will be considered after service upon the sole respondent. After service of notice upon the sole respondent, notices are returnable 3 weeks, AD, Dasti.
Item 28.
Oh, here the impugn order, Malot, passed by the learned Arms Court Terminal 3/4/2023, Malot.
30 to
Similar issues
50%.
are already pending for a lawsuit.
30 to 50%. This is what the order of the tribunal. Grant of pension instead of 30%, 50%.
Malad, not attributable to the Malad service, Malad, the disability is not attributable to the service, Malad. And the similar issues are for losses, your losses are protected, Malad. This is the other, Malad. The matter we take along with this matter. And
Same order.
It order to আছে এটা চাই পেলাই কৰিব
Item 29.
Lord, this is my lord challenging an order of the administrative tribunal at page 240, my lord. The matter related to promotion. The issue was that the time-bound promotion was not granted because there were certain adverse entries that were there in the ACR. The tribunal, my lord, had overlooked the fact that, my lord, there was a representation against those adverse entries, which the competent authority had rejected. But in spite of that, the tribunal comes to a finding that those adverse entries are to be expunged and therefore a review DPC is
Why
to be.
you not filed response before the tribunal?
My lord, we have filed.
You have filed.
We have filed. The response was filed.
How the tribunal has dealt with those response? Means the tribunal is of the opinion that you have not communicated the adverse entry.
My lord, that is, my lord, a wrong finding, my lord. The tribunal has proceeded in the line of what Visit Ghosh Dastidar has said. In those cases, my lord, the Supreme Court says that it has to be communicated. Communication was there. Not only communication was there, there was a representation against those communications.
Up to a considerable time.
came to know only from RTA.
When these ACRs were communicated to the applicant,
My lord, there was a representation made, my lord, by him. It came in 2013, my lord. The communication came in 2013. There was a representation thereafter. my lord,
which year?
Of 11, 12.
11, 12.
11, 12.
Those were communicated in 2013.
13, and in July 2013, there was a representation against the same, my lord, which ultimately, my lord, was rejected, and there was an appeal against the same. The appeal also was turned out in 2018.
ये एग्जामिन करना पड़ेगा क्योंकि ट्राइब्यूनल ने प्रमोशन दे दिया
देखिए हमने concept of they submitted that tribunal that the CAT has had in observing that there was a delay in communicating the adverse entries to the respondent. It is submitted that as a matter of fact, the adverse entries related to year 2012 and 13 were duly communicated to the respondent, and he has also filed representation against the said entries which came to be disposed of in July 2013.
13, and finally the appeal disposed of on 20th.
July 2013.
18, my lord. The appeal in 2018.
July 2018.
18, my lord. 18. There was an appeal also, my lord. The original disposed.
You took 5 years for
No, my lord.
deciding the objection.
No, the original objections were decided by the authority earlier. This was in 2014, my lord.
2014.
29/11/2000.
Issue notice. Issue notice of stay application. In the meantime. Returnable on the 8 weeks. AD Dusty. In the meantime. Effect and operation of the interim order passed by the tribunal dated. What's the date of the interim order?
My lord, 5th October 2023.
By the Central Administrative Tribunal Guwahati Bench in original application number 040/0036/2018. Dated 5th of October 2023 shall remain stayed.
The respondent is retired in 2000.
He has retired. He subsequently also got the time bound promotion.
Only
not-
effect in this order is that tribunal has granted him promotion.
My lord.
Otherwise, you have nothing.
My lord.
Item 31. बाद में रहने वाले में बाद में इस कैटेगरी में ज्यादा आता है Everybody wants to no one wants to.
Hello, sir. I'm appearing on behalf of the amicus today. As per the last order, my lords have instructed them to file an affidavit, take a stock regarding the sheltered homes. I've received a copy of the affidavit. That's fine.
Comprehensive compliance report is filed on behalf of the state legal,
Yes.
services.
They have provided a comprehensive report with regard to the facilities that exist and also the number of the.
Deficiencies.
Yes,
they
yes,
also pointed
those are also observed in the report. But more importantly, one of the, this issue of the PIL was with regard to the eviction and the resheltering of the people. And more importantly, the welfare of the children.
Yes.
Yes, so now with regard to that, the report that has been filed, the children that has been relocated in those families exist of more than 700 children. But if we go through all the reports, they have some facilities, they have some shortcomings with regard to funds and other facilities, but they do not meet the requirement of more than 200 or 150 all across the shelters if provided altogether. Matlab, what I mean to say is that there are 700 plus children that those were affected by this eviction drive. But the sheltered homes that are provided in this report altogether do not have a capacity with more than 150 or 200 children to accommodate at once. And they're already children, those are already in place in those shelter homes. So that is, I believe, a separate issue here.
Mr. If they are evicted from one place, then some adjustment has to be done. Suppose if the capacity is of 100, then they can accommodate 125.
Yes, yes, dormitories could be made.
But that has to be done. Yes.
But here, Malad, the ultimately the issue has been taken somewhere else, Malad. Lordship may kindly appreciate, Malad. This PIL was registered. They kindly see the first order, Malad, 21/4/2023. It was on the basis of a newspaper report that there was a eviction drive at Noga, Malad. Then the evicted persons, they have taken shelter in a temporary place, Malad. There, the condition of the temporary shelter was not good. That is why this PL has been registered and that has been taken care. The latest instructions which I have placed before the Lordship is that the evicted persons, they have been given some land. and these persons, they are, my lord, kindly see, my lord, the report. I have received it, my lord, from the Deputy Commissioner, Hojai. Already land has been given, and they are,
When you have filed,
my lord, I have submitted it today, my lord, today in the morning, my lord.
Where is that?
Just I have given the copy, my lord.
This one. This letter.
Yes, my lord.
Here.
But the DC has informed that I have the honor to inform you that the 304 number of affected families residing in temporary shelter homes at Sengmaji Grazing Reserve of Sengmaji Kisam, Jamunamuk so-and-so were allotted land at Jamunamuk Moudanga Krishi Farm Nigam Kisam, village so-and-so, by letter number 13/3/24 and letter number 22/5/23, but no family has shifted to the said allotted land till date. They are residing at Sengmaji Grazing Reserve in a temporary shelter. The facilities like water, health service, AIC activities are being done regularly at the temporary shelter homes. That is the present position. But so far the report submitted by the Asalsa, this is regarding to the shelter, the childcare institutions or the children home already existed in the state. But this has nothing to do with the temporary shelters. Lordship has on previous occasion directed the state to get the information how many temporary shelter homes are there in the state. Then the report came that there is no temporary shelter home apart from that this particular thing at Dobota. So other shelter homes which the report has come now that the condition is this and that some things are required. These are not temporary shelter homes.
Whatever it may be. Ultimately, yes, initially, this writ petition was registered, taking into consideration the situation of or condition of the children in the temporary shelter homes, but we have expanded the scope of the petition.
In fact,
Now we have asked this Assam Legal Services Authority to conduct a survey and place the report on record. This report is already there. Yes, certain measures are there, but there are certain deficiencies. State should comply with them regarding fund and you should comply with them.
I have my submissions.
Yes.
But as regard the shelter home, conditions of shelter home and all these things, there is a Supreme Court decision, and as per that decision, another PIL has been registered. It is going on. PIL 60 of 2019. There, I have the orders. Kindly, I have two orders. Kindly peruse the orders. The
This
court
is of 2023.
But this PIL 60 of 2019 is going on.
Yes.
And there, I have this one I put on. Kindly see the order dated 22/9/2022.
Yes.
Kindly take para 5. This has been registered pursuant to the Honorable Apex Court decision. I'm just indicating para 5 as indicated in the previous order. The state court appointed committee. Court has already appointed a committee for inspection of all the homes. The court appointed committee would be required to visit various children observation special homes in the state and also to see and report if there is proper implementation of various directions and of children rights laws as to ensure that various directions contained in the case of Sampurna Behura versus Union of India is complied with. Then kindly see the next order, kindly see order dated 10/10. I have given the other order also. Ten table. Paragraph 2. 10/10, paragraph 2. On 22/9/2023, this court had issued certain directions in this matter. In respect of the directions contained in paragraph 4 thereof, the learned so-and-so has placed on record communication so-and-so. The following names with the designation of the officers for appointment as members of the High Court notified committee. So these are the names. Ultimately, the committee has been appointed, and this committee is doing the inspections, and they are submitting reports before the Honorable Court. Para 4 kindly similar.
Ms. Chaudhary, you see, this report of Asalsa clearly shows that there is at least one temporary shelter in Nagaon. How many children are there in that, and do you know what is the condition of the children?
The exact figure to us, they've just said that certain children are there, but they're trying to provide all the facilities for those children who are there. Unfortunately, the figure is not with us.
Who is trying to provide that?
What the DLSA has provided, the DLSA Nogam has given the report. If I may just place the.
But in fact, that is not a temporary shelter home for children. The parents are with them. All the families are there with them, their children are with the parents, Lord,
But
there
since
at that
now-
place.
now-
Look,
now
I'm
this
I'm just indicating the other PIL. Look, the honorable court
Okay, we'll do
appointed committee,
We'll list this PIL along with that.
correct. And Lord, in that, Lord, the
But
PIL,
in the meantime, the report submitted by the Assam Legal Services Authority, on the basis of the reports given by the DLSS, there are certain deficiencies. What measures you are taking to cure that
Lord,
deficiency?
I am just indicating, Lord, if Lordship kindly takes up the Juvenile Justice Act, Lord,
Yeah,
the particular court appointed committee, they are inspecting the homes, submitting the report as indicated in Form 46. Form 46 is very detailed formula. All details are available in that, Lord.
so submit those forms if they, your
Lord,
forms
these
are with
reports-
you,
Lord,
submit
these
those reports in response to this,
The court-
report.
Court appointed committee is inspecting, Lord. They are submitting the report before the honorable court. That is what I am indicating that in as regard all the children homes, whatever report now it has been placed before your lordship. These are
Mr.
not,
Counsel,
these are not detailed, my lord.
Mr. Counsel.
These are not
now-
detailed.
Now the affidavit is filed on behalf of this Assam Legal
Yes.
Services Authority. And wherein the data is collected from the DLSS is already on record. They have pointed out, they have specifically mentioned these facilities available, this facility is not available. What measures the state government is going to take to cure that deficiencies, you please file an affidavit of this effect. We'll post this writ petition along with the pending writ petition. That's all. Do you have any objection in
No,
that?
no, that let
Then
let
don't-
go.
why
let
why
go.
you are arguing that?
No, I am arguing because let this matter go there, my lord. Otherwise the inspection is
Certainly,
going.
it will go there, but in the meantime, you file your response to this additional affidavit filed by the Legal Services Authority.
Yes,
Leak-
and can you see, my lord, page 59, this is also old age home. Old age home is also, they have indicated.
No problem. Leak-
This is besides the issue, that is what
And,
I am indicating.
affidavit is filed on behalf of the some member secretary of the Assam Legal Services Authority. Along with the data collected by the respective district legal services authorities regarding the condition of the children homes situated in the state of Assam. Full stop. In the said reports submitted by the respective district legal services authorities, the facilities available with the shelter homes for the children, elderly people, and other category persons have been mentioned along with the deficiencies. Full stop. The concept of the state of Assam may file affidavit detailing out the measures which the state government has taken or proposed to take to cure the deficiencies pointed out by the DLSS in respect of the shelter homes of different categories. It is also, it is submitted by the Learned Council for the respondent state of Assam that on an identical issue, PIL number 60/2019 is already pending consideration before this court PIL number 60/2019 and PIL so 1/2020, 2018 are already pending consideration before this court. Full stop. In view of the above, we deem it appropriate to direct. We deem it appropriate to grant time to the concept for the respondent to submit his response to the affidavit filed on behalf of the Assam Legal Services Authority, member, Assam Legal Services Authority,
Member Secretary.
member secretary by the next rate of hearing. List along with PIL number 60/2019 and 1/2018.
Item 33.
But in this case, lordship, the notice was issued on the writ appeal, my lord, on upon the respondent number 6 first, my lord, step we missed out, my lord. So again, 1 week time may be granted, lordship kindly, because I'm ahead. Otherwise, just a week time. We'll take on the respondent number 6.
People are placed for and granted a week's time to do the needful.
Respondent number, diploma.
Item 34.
Affidavit. They had filed an affidavit yesterday, lordship. I have got a copy, lordship. Lordship, they want to make 30% reservation, lordship, for the people of Golaghat, lordship, from employment exchange Golaghat specifically. And lordship, as per law, that cannot be done, lordship. The Supreme Court guidelines are also there, lordship. They have to.
You want to file rejoinder? No.
No, lordship. I will
You
file
be
it, lordship.
accepting this and
Lordship, I will file it. Lordship, yesterday only I.
Okay. Affidavit is filed on behalf of the respondent number 4, 5, 6 and 7. Justify the action of the Numaligarh refinery to provide 30%, to provide a reservation of
Grade 4 and 5, lordship.
provide reservation to reserve 30% of the vacancies of grade 4 and
Grade 4, 5 and below, lordship. They have different grades.
4,
lordship.
5 and below
for the residents of Golaghat.
for the residents of Golaghat districts, district. London Council appearing for the petitioner creates some time to file response to the affidavit filed on behalf of the respondent number 4, 6 and 7. Time paid for is granted. List on
2 weeks, lordship.
2 weeks.
March only.
Item 45.
कोई आया नहीं चार हफ्ता तक एग्जाम नेक्स्ट डे पिछली बार भी ये था और भी
None present. It is noticed that no one is present on behalf of the petitioner, the petitioner in person is not appearing in the matter, has not appeared on the last date, that is 1/3/2024, and today also. However, in the interest of justice, matter is adjourned for 10 minutes.
Item 36.
Please, your lordship. The respondent filed affidavit, I also filed a reply, my lord. So take the matter for hearing, my lord.
Petitioner place some time to file. Counter to the affidavit filed on behalf of the respondent.
Respondent filed, I also.
We have filed, my lord, they have also filed a reply, my lord.
You have filed.
My lord.
Pleadings are complete, my lord.
Yes,
My lord, not take the matter for hearing, my lord.
it is not for a hearing.
Admission, my lord.
Okay. The pleadings are complete and the concept of the parties have played that matter may be listed for hearing. List for the hearing.
Admission.
Pleadings are complete. Having heard the land concept of the petitioner, we deem it appropriate to admit this petition, hence admit. No need to issue notice as parties are already represented. List for the hearing in the month of August.
Oblige, Lordship.
Item 37.
May I please, Your Honor? Some time may be granted to file affidavit in reply.
Affidavit,
In reply.
and concept of the petitioner place for an granted time to file. Counter to the reply filed on behalf of the respondents. It's up to 4 weeks.
Pass over matter 17.
Second call. What to do?
Lordship, in spite of the last order, Lordship, no copies were served, Lord. Now I'm unable
Is
to,
there any stay? Nothing.
nothing, Lordship.
Okay, none present for the petitioner even in second round. In the interest of justice, list after 6 weeks.
Supplementary list, item 39.
Yes, my lord. I have received a copy of the appointment letter, my lord, which was issued day before yesterday.
Yes, Mr.
If you.
We will take instruction if she is joined. Join and then.
Nikhil, and the concept of the respondent state has submitted that the government of Assam, Director of Geology and Mining Assam has already issued appointment order in favor of the petitioner on appellant on 29/4/2024. A copy of the order dated said order is produced on record. The same is taken on record. And the concept of the petitioner appellant plays some time to ascertain whether the appellant has joined pursuant to the appointment order or not. List up to 10 days.
A copy of the order, appointment order also handed over to my lord.
Yes, my lord.
Very clear.